Lady, my lords, I'll begin, if I may, by picking up on some of the issues raised by the court and by my learned friend this morning before going on to develop our own case in a perhaps more logical way. I'll begin, if I can, with the decision of this court in Perry. If I could take the court to page 753 in the paper, 755 in the electronic bundle. And first to paragraph 19 in this court's judgment in Perry, which is a paragraph my learned friend referred to on a number of occasions in support of his assertion that the matter in the present appeal needed to be tried out with all the adversarial rigour of a trial. And paragraph 19, read on its own, might indeed have provided him with that support. But paragraph 19 must be read in its true context, which is in the context of the paragraph that follows. And what Lord Briggs went on to say in paragraph 20, for present purposes, the courts have developed a clear and common sense dividing line between those matters which the client must prove and those which may better be assessed upon the basis of the evaluation of a lost chance. To the extent, if at all, that the question whether the client would have been better off depends upon what the client would have done upon receipt of competent advice, this must be proved by the claimant upon the balance of probabilities. To the extent that the supposed beneficial outcome depends upon what others would have done, this depends upon a loss of chance evaluation. So this court is there, albeit obiter, setting out a very clear dividing line between those issues which do have to be tried out with all the rigour of a trial, and which a claimant is required to prove on a balance of probabilities, and those other issues, or the other issue, which is to be determined upon a loss of a chance. So as we make clear in our case, yes, the claimant had to prove breach. Yes, he had to prove, or she had to prove, that the claim would have been continued honestly, because those were matters that fall within the first category. But once that is established, the question of whether there is a loss and to what extent there is a loss falls into the second category in paragraph 20. To the extent that the supposed beneficial outcome depends upon what others would have done, this depends upon a loss of chance evaluation.
Would you not have to prove that there had been some loss, that the lost claim was of some value?
Well, the loss that the claimant has to prove is the loss of chance, because without that, it entirely undermines the dichotomy that's set out in paragraph 20. If the claimant has to prove on balance some loss, then the claimant will have proved on balance what that loss is. The distinction that's being drawn here by Lord Briggs is in relation to the extent, if at all, that the claimant would have been better off. So if at all, plainly has in mind whether there is any loss at all. So it's not merely the quantification of the loss, but it's the question of whether the loss is suffered at all that's envisaged in this passage of being a matter that's to be determined as a loss of a chance. So once the claimant gets to the stage of loss, once the claimant has proved all the things that the claimant has to prove on balance, in relation to loss, that issue, whether there is a loss at all, and if so, how much, is to be determined upon a loss of chance.
Having regard to the classification by Lord Justice Simon Brown in Mountain Austin, the first category he identified required that it should be established on the balance of probabilities that the claim was of some value.
Yes.
And in the context of a case such as this, where what has been lost is the opportunity to recover more than the amount of the settlement, doesn't that involve establishing?
No, because the value here, I think everyone agrees, as a matter of fact, the claimant, or Mr. Watkins, had a chance of being in fact better off in the absence of the negligence. The appellant position is not that the claimant or Mr. Watkins would not have been better off and therefore has not suffered a loss. What they say is that this is not a loss that justice should allow for recovery in respect of. Plainly factually, he's worse off. Factually, he has lost the opportunity to proceed with the services claim and to recover under the scheme. So there's a factual loss of benefit. That's not in dispute here. What's in dispute here is should the law compensate a claimant who has suffered a factual loss in the circumstances we're here concerned with. So in our submission, it plainly falls within the first category in Baker. Claimant in a case like this does prove that there is some factual loss. This is essentially a policy argument that's been argued out before this court. This dichotomy between those issues that are to be tried out on balance and those that are to be determined as a loss of a chance then goes on to have an effect on the evidential issue that my learned friend raised. He suggested that the respondent's position is that no after-coming evidence should be considered by the court. That is not our position and has never been our position. It's plainly the case that in relation to those issues which are to be proved on balance and are to be tried out, plainly all the evidence that relates to those issues should be considered by the court, including after-coming evidence. And that's always been the case in this class of litigation, and indeed was the case at this particular trial. And indeed, that may well include medical evidence, and it may well include the expert evidence of Mr. Tennant. So Mr. Tennant's evidence was certainly potentially relevant to the question of honesty. It was plainly potentially relevant to the question of whether, if properly advised, Mr. Watkins would have pursued his claim. And the judge rightly was entitled to take account of that on those issues. What my learned friend suggests is that it would be, I'm not sure you use the word impractical, but it would not be appropriate to ask a trial judge to have regard to a particular piece of evidence or category of evidence on one issue, but not have regard to it on another issue. Well, of course, that's what trial judges do all the time. Inevitably, there is all sorts of pieces of evidence at trial. Some will be relevant to some issues, some will be relevant to other issues. And it's no difficulty at all for a trial judge to say, well, I'm going to look at this evidence for that issue, but it's not relevant to another issue, so I disregard it. So that
the aftercoming evidence is clearly relevant to some of the issues of quantification, like what can he do, what can't he do, what does he need assistance for, and comorbidity. So it's clearly relevant to all of those things. But you're saying it's not relevant at all to whether or not he is actually disabled.
No, whether he's actually disabled may have an impact on whether or not he could have brought an honest claim, and it may have an impact on whether he would have brought a claim if properly advised. It's plainly relevant to those issues.
Both of those things one understands. I'm asking you more than that. Not, of course, whether there's any suggestion of setting aside the initial assessment and the initial award. There isn't. It's a question of what's the value, if any, of the services claim, which, because of negligence, he hasn't made.
Yeah. The reason, what it's not relevant to, is the correctness per se of the MAP 1 assessment.
Yeah.
Because the MAP 1 assessment, as my Lord Sales has pointed out, was never going to be challenged in the course of the scheme.
But I think, well, the consequence of the MAP 1 assessment isn't going to be challenged.
The correctness of the MAP 1 assessment was never going to be challenged in the original scheme. But it is being challenged, or was thought to be challenged by the appellant in this claim. Now the question is whether or not that is relevant when assessing the prospects. As a matter of fact, it plainly doesn't affect the prospects. As a matter of fact, Mr. Tennant's evidence was never going to be considered in the course of the scheme. So as a matter of fact, it's irrelevant, but what's being suggested is that that's not the point. What's being suggested is it's unjust to ignore it. And I'll come back to deal with general issues of justice in due course, if I may. I'll turn now, if I can, to the order, the Hawksworth order, and the reasons for it, and the judgment that was handed to the court just before the adjournment. And if I can take the court to paragraph 7, whereas on Judge Hawksworth...
Paragraph 5 is quite interesting because that was the basic debate as to whether it should simply be a MAP 2 assessment or whether something more complex was to be permitted. I can see the argument that it should simply be what would have happened if the services claim had been made. But paragraph 7 indicates the argument that it could be relevant to more issues than that.
Well, certainly paragraph 5 deals with what appeared to be and what much of the time was spent debating in the course of the hearing. But it was... Paragraph 7 makes clear the purpose for which the insurers were contending there should be this evidence, which is highly pertinent to this court's consideration. So His Honour Judge Hawksworth said this: during the course of submissions, however, it became clear that defendants were not contending for medical examination in order to revisit the diagnosis of VWF, but in order to evaluate the claimant's case on causation. Pausing there for a moment, that's precisely an issue that the claimant is required to prove on balance. Ms. Foster, who represented the defendants, submitted that medical evidence was required in order the defendants could investigate and evaluate the claimant's condition from the date of alleged negligence advice up to the present, a period of possibly in excess of 10 years or so, in order to determine whether and to what extent the claimant had been disabled by his HAVS injury. This would shed crucial light upon whether his failure to pursue a services claim arose from negligent advice or from an inability to truthfully assert that he had lost the ability to perform those specified list of activities which would enable him to bring a claim for a services award. Pausing there, that's precisely the issue that this court was concerned with in Perry, the ability to honestly pursue a claim. She submitted by detailed reference to the MAP 1 procedure, and this medical examination was predominantly directed at diagnosis and staging of the HAVS condition, not in assessing the level of disability present. Ms. Foster did not seek to say that the fact of a MAP 1 diagnosis and its consequences for the subsequent progression of the services claim could be called into question. However, the defendants were entitled to investigate the implied averment that had the claimant been properly advised, he would have made a services claim. So this is emphatically the way that those defendants on that occasion were putting forward the justification was the issue before this court in Perry, not the issue before this court today. And that's then reflected in the draft letter of instruction to experts, which your lordships will find in front door.
Well, paragraph 11 does say what the broad question to be addressed by the examining doctor was, which is in the letter. Whether and to what extent the claimant was at any material time disabled by his vibration injury in carrying out the tasks listed in respect to which he claims he lost the chance to claim.
Yes, but it goes further than that in the directions order because it makes clear the reasoning behind the letter. I'll just take your lordship's moment to the draft letter. It's page 468 in the paper bundle, 470 in the electronic. And it's the fourth paragraph on that page. So the draft letter instruction to the expert is this. It is an issue in the proceedings whether Mr. X would, if properly advised, in fact have brought a services claim at all, whether Mr. X was, as a result of halves, in fact disabled from carrying out in whole or in part the tasks he alleges, would have formed the basis for his services claim, is relevant to that issue. So it's making clear that the purpose of the instruction of the expert in this regard is the issue that was before this court in Perry, not the issue that's before the court today. And that wording was adopted verbatim in the letter of instruction, in this case, to Mr. Tennant. That, we say, is absolutely, fairly and squarely an issue that Mr. Tennant, or medical expert, was properly required for. It was an issue that the claimant was required to prove on balance, and to that extent, the judge was properly entitled to and should have considered it for that issue. Moving, if I can, just to touch on Bulfer, which I'll return to in due course. There is, in our submission, a very important distinction between those cases to which Bulfer does apply and those that it does not. Bulfer applies, we say, to events, not evidence per se. So in relation to an event that has not occurred at the time that loss has been suffered, but occurs subsequently, before the matter comes to be finally tried, is an event to which the Bulfer principle applies. In Bulfer, it was, on its own facts, the market price of coal. In the Golden Victory, it was the Second Gulf War. But these are events that occur subsequently to the loss being incurred. What Bulfer does not apply to is after coming evidence in relation to a matter which had already occurred at the time of loss. So in particular, in the present case, it does not apply to Mr. Tennant's view, if he expressed a view, and I'll come back to that in a moment, to Mr. Tennant's view if he expressed a view about the correctness of the MAP 1 staging. The staging at the time that the loss was incurred was already a past event. There is no subsequent past event which has occurred to bring this within the Bulfer principle. And I'll come back to deal with Bulfer in more detail in due course. The fifth issue that my own friend raised, which I need to address at this stage, is the underpinning assumption of his submissions that Mr. Watkins was, I think in the words of my Lord Thomas, the beneficiary of some good luck. We don't accept that. It's right that the recorder found as a fact that Mr. Watkins had always been 1v1SN, but that was a finding of fact which was overturned, we say, on appeal, and appears to be accepted as having been overturned. We say rightly so. I set out in some detail in our written case pages.
I don't understand. There was the only evidence that you had before the court was that of the expert. And that's the evidence he gave. I don't think it's been overturned. It's just there.
My Lord,
weight we give.
my Lord, one would think, listening to my own friend, that he had given that evidence, but he had not given that evidence. What he said was that at the time that he examined Mr. Watkins, some years later, that is what he found. But he wasn't asked to comment on the correctness of the map 1 back in 2000. He didn't comment on it in his report. And in fact, when he was asked to comment about it, when those instructing me asked Part 35 questions, what he said was that the vascular finding, the 3V, was properly justified on the basis of the account that Mr. Watkins had given at the time, and the sensorineural grading, the 3SN, was similarly justified on the basis of the testing that was undertaken at the time of the map 1. Well, these are points I set out in detail in our written case, but there's a point that doesn't appear there which I would draw your lordship's attention, your ladyship's attention to. Page 308 in the bundle. This is Mr. Tennant's report, and at the bottom of section 8, he refers there to the table he goes on to construct on the following page, and this is essentially him undertaking a shadow map 2 assessment where he considers comorbidities and disability. And your lordships will notice that at the bottom of paragraph 8, he says this: the tables below are constructed on the basis of 3V3SN as at the map 1 report. So, insofar as he's not commenting on the accuracy of the map 1, but when he prepares his report, rather than saying at that stage, I'm going to do it on 1V1SN because that's my view about what the true position was, he doesn't do that. He simply...
There would be none. If there's no scope at all.
Well, my friend will have a chance to respond in due course. But when constructing this, he is constructing on the basis of 3V3SN. One might have thought that if he had come to the view that the map 1 was incorrectly graded, there were plenty of opportunities for him to say that in his report. And indeed, as my learned friend rightly points out, he and all experts are positively invited to say if they think that there is no VWF. But at no stage does he say that. The sixth point my learned friend raised I need to address is paragraph 28 in Perry, in the Supreme Court, page 755 in the paper 757 electronic. Where Lord Briggs says this: applied to the present case, Mr. Perry could only have brought an honest claim for services award if he believed that A, B and C. And C is the reason for his need for that assistance was a lack of grip or manual dexterity in his hands brought on by VWF. As I understood my learned friend's submissions to you this morning, he was suggesting that the reason for the need for assistance had to be VWF. That's not what paragraph 28 says. What paragraph 28 says is that a claimant has to believe that is the reason. It's not saying that it has to be the reason. Of course, that's because paragraph 28 is dealing with honesty. The next point to be dealt with at this stage is my friend criticised the dichotomy in our case of contrasting the earlier date with the later date as a false dichotomy. First point, of course, is that that's essentially a dichotomy set up by this court in posing the question. The question poses two alternatives. Is it the date at the time when the claim was lost, or is it the date at the professional negligence trial? And whilst it is right that the earlier date needs to be established, it's not always immediately obvious what that earlier date with. Conceptually, there is an earlier date when the claim is lost, and inevitably a court will determine what that date is, because that forms the foundation of any assessment of loss. And the final point to respond to in relation to this morning is this, that my learned friend is suggesting that what the court has to look at is everything that is now available, with one exception. And the exception, it is suggested, that the court must ignore is the fact of and the operation of the scheme. In my submission, that is a suggestion without any proper or sensible basis. I'll turn then, if I can, to develop our written case in perhaps a logical way. And can I start this section by really dealing with the question of injustice? I said I'd come back to it, because that's, in our submission, what underpins the appellant's case. They're effectively saying, yes, Mr. Watkins would have been better off in the absence of negligence, but it would be unjust to us if the court ordered us to compensate him for that. In our submission, it's a solicitor doing this kind of work goes into it with their eyes entirely open. The rough and ready nature of this sort of scheme gives rise to the kind of award that Mr. Watkins would probably have got if he had pursued it. It's, I think, as various of your lordships have suggested, an inherent part of the scheme that ultimately the awards made are not necessarily going to reflect the underlying truth. But solicitors who do this get the benefit of the rough and ready nature of the scheme. They know that an overwhelming proportion of the cases that they bring will be paid out under the scheme, and accordingly they will get their costs under the scheme. They make a commercial decision to undertake this kind of work, and no doubt they insure appropriately in the circumstances. No one is making them do this kind of work. They have chosen to do it. If they don't want to face the sorts of consequences that they may face in a case such as this, they don't have to take on the work, or perhaps without being glib, they have the choice of doing it in a non-negligent way. To suggest that somehow they are the victims of an injustice which requires the court to protect them from, by departing from the normal rules of restitutio in our submissions, does not stack up. The alternative is that claimants such as this, or Mr. Watkins if he'd not died, are required many years later to prove to the court the nature or the extent of the loss that they have suffered, in circumstances where they were making an honest claim in the first place, and in circumstances where they're only put in this position because their solicitors have been negligent. Typically, under this scheme, the claimants are men often in old age, sometimes to the extent as in the present case where they have died by the time the matter comes on for trial. They're often, as previous authorities have made clear, relatively unsophisticated claimants with little or nothing by way of written records. And they are in often a difficult position when it comes to proving the extent or the nature of the loss they suffered many years earlier. It's also, we would say, particularly inappropriate to require that sort of re-examination with a full trial, expert evidence and the like, in circumstances such as this, where the original claim arises from a rough and ready scheme, a point that Lord Justice Irwin made in the Court of Appeal's judgment in the present case. So we say that the underlying basis of the appellant's position, that somehow there is this injustice that they need to be protected from, really does not stack up on a true analysis. The way in which the matter was presented this morning, one might have thought that this case had been decided at first instance on the basis that the appellant is now contending for. That was not the basis on which this case was decided by the learned recorder. The arguments that are put today have been put throughout this case and were put to the recorder. The idea that he should not concern himself with assessing a loss of a chance, but should be looking at what has been termed in the appellant's paperwork effectively the true value. He rejected that. He did not find for the appellant on the basis they contended for. He found for the appellant on the basis of loss of chance. He makes that very clear in his judgment. Now, he found for them on a different basis, which I shall come to in due course, but he emphatically found for them on the basis of a loss of a chance. Because what he said was that if the parties had had available to them at the time the evidence which is now available, Mr. Watkins' chance would have been essentially zero, and as a result, the claim failed. In other words, what he was positing was a particular counterfactual situation. And of course, the counterfactual situation that is posited by a court is crucial in any assessment of loss of chance. And if I could take your lordships to the way this was dealt with by Lord Briggs in this court in Perry, page 752 in the paper, 754 in the electronic.
Paragraph?
Paragraph F.
No, sorry, the main paragraph.
Oh, beg your pardon, 17, I apologise.
Thank you.
Paragraph 17. I beg your pardon, it's 16. I do apologise, my lord.
Thank you.
Paragraph 16. Commonly, the main difficulty arises from the fact that the court is required to assess what, if any, financial or other benefit the client would have obtained in a counterfactual world, the doorway into which assumes that the professional person has complied with, rather than committed, a breach of his duty of care. So that's the basic counterfactual approach. In our submission, it's the standard counterfactual approach. It's a counterfactual approach we have contended for throughout, and the counterfactual approach that the Court of Appeal took in the present case. One simply asks, what would have happened if the professional person had complied with, rather than committed a breach of their duty of care? the learned recorder, adopted that in the large part, but made a very significant departure from it. If I could take your lordships to your ladyship to page 157 in the bundle, which is the judgment of the recorder. Beginning in the final paragraph, I would not characterise the two approaches.
Oh, that's not 157.
So 157 in paper, 159, I apologise, on the electronic. So it had been advanced to him the appellant's effectively true value argument and the respondent's, we would say, standard established loss of a chance argument. And he says this: I would not characterise the two approaches of the assessment of loss respectively urged upon me by counsel as mutually exclusive. They are complementary and both potentially relevant depending upon the facts of the individual case. If, as here, expert or other evidence which post-dates the settlement or other disposal of the original claim establishes beyond any or any but negligible doubt that the claim could and would have been resolved only in one way, so only one specific way, had that evidence been available to the parties and the tribunal at the time. So that's the counterfactual he is positing. Then the court in the professional negligence action has the full facts adverted to by Laws LJ in Whitehead and should find accordingly, thereby avoiding an uncovenanted windfall or correcting an injustice to a claimant whose case has turned out to be undoubtedly stronger than had previously been assumed. In the case of Mr. Watkins, I can and should find that his chosen action has been shown to have had no value given the damages actually paid to him. Putting it, as I've found on the full facts, the services claim has no chance of success. So very clearly there, he's considering the prospects. For the same reason, it's beyond peradventure that faced with Mr. Tennant's clinical findings and conclusions, any award would have fallen short of 9478. It's fanciful to assume otherwise. In cases such as Barnaby, how the original case would have been resolved, even if all the material evidence now available had been to hand at the time, will not be clear beyond doubt. In that event, the court in the professional negligence action must, of course, assess the value of the lost chance.
That reflects the approach of Lord Justice Simon Brown in Mount.
Yes. Save only that the approach of imagining that the court has available to them at the time evidence which subsequently comes to light, my submission is not the approach in...
That doesn't appear there, but the compatibility of the two approaches reflects Lord Justice Simon Brown's approach.
Yes, my Lord, the point I make is that, that the key distinction here is that in setting up the counterfactual situation, which is required before one can go on to assess the loss or absence of a loss of chance, what the recorder is doing is imagining a situation in which later evidence is effectively time transported back and is made available to the parties to the original claim. Now that was not something which was raised at all in the course of the trial. It certainly wasn't an approach advanced by either of the parties, either before or since, and it appeared to be essentially a creation of the recorder himself and appeared in his reserved judgment. It's not taken up or adopted as we understand it by the appellant in this appeal, and so far as we're aware, is wholly unsupported by evidence. So, on any view, the approach that the recorder took was plainly wrong. And in our submission, the counterfactual situation to be set up is that set out by Lord Briggs in Perry, the passage I took the court to, which is the standard approach. Simply asking, what would the situation have been in the absence of negligence? One doesn't have this fanciful idea of transporting evidence back in time. Now, my lords, my lady, that's the basic position, but it is subject to some very important qualifications and exceptions. So there are two qualifications. The first qualification that is that the counterfactual is not merely the evidence that was available at the time, but it's also the evidence that should have been available at the time in the absence of negligence. And one could see the obvious logic for that, because one is imagining what would have happened in the absence of negligence. And the cases of Charles and Duderek are examples of precisely that. In both cases, the courts found that later medical evidence should have been available at the time of the putative trial or settlement in the absence of negligence. And we say that's the ratio of those cases, and that was the approach set out in the judgment of Lord Justice Irwin in the court below. So that's not an exception, but it's plainly a qualification. It's an application of the principle of restitutio in integrum. What would have happened in the absence of negligence, this evidence would be available, therefore that forms part of the counterfactual. The second qualification is that evidence of the original party's attitude to settlement is admissible. The case of Sir March, which my own friend referred to this morning, is an example of that. Again, an important part in all cases, but particularly scheme cases such as this, is what was the prospect of the matter concluding before a full trial. And the attitude of the parties to settlement may plainly be relevant to the court's assessment of those prospects. That evidence, by definition, will always be aftercoming. I then turn to the exceptions to the general approach to the counterfactual, and they are essentially two. The first exception is evidence of dishonesty or misconduct. As a matter of public policy, the courts do not reward claimants in relation to factual losses that they have sustained, which arise only by virtue of their dishonesty or misconduct. Perry, of course, is an example of dishonesty. Mr. Perry could not prove he would honestly have pursued a claim, therefore his claim could not succeed. And the case of Green, which I won't take your lordships to, but is in the bundle, is an example where the claimant had failed properly and fully to disclose material which should have been disclosed in I think, divorce proceedings. That was a misconduct, and again, the court was not going to reward any factual losses suffered only by reason of that failure to disclose. That brings us then to the second exception, which is Bulfer. I've already highlighted the key feature of Bulfer, where I think the parties disagree. Can I deal with the question of date, the one that's specifically raised in the question posed on this appeal? And specifically, the parties were invited to consider whether Bulfer assisted on date. Bulfer, in fact, proceeded on an agreement between the parties that the relevant date was the earlier date, not the date of any subsequent trial. That's set out in the Court of Appeal judgment in Bulfer. So Bulfer does not consider the question of date, but proceeded on that basis. for your Lordship's notes, or Ladyship's notes, it's 772 in the paper, 774 in the electronic. So I've submitted to your Lordships that Bulford does not apply to later evidence per se, certainly not to evidence of matters which had already occurred at the time of loss. But it brings me on to the case of Whitehead, which is in many ways the most significant authority in this matter, because in our submission it's the only authority or example where the courts have departed from a conventional restitutio approach to a loss of a chance calculation. And that's precisely what we say you are being asked to do on this appeal. Now, the first thing to note about Whitehead, and if I could take your Lordships and your Ladyship to page 858 in the paper 838 in the paper, 840 I think in the electronic, yes, 838 in paper, 840 electronic, and paragraph 17. What Whitehead is not purporting to establish is a general exception to the general rule that I'm inviting the court to. It is dealing with an exceptional or unusual case. Paragraph 17, third line, what Lord Justice Law says is this: in most cases, let me go past that. The end of the first line. The purpose and award of damages is to provide just compensation for a wrong done to the claimant. In most cases, that purpose is given effect by the general rule that the claimant is to be restored to the position in which he would have been had the wrong not been committed, so far as that can be achieved by money. So at that point, Lord Justice Laws is in our submission setting out the established approach which we invite the court to in this case. To attain that result, the court has to reconstruct events which in fact never happened, but would have happened but for the wrong. Again, that's the counterfactual that we invite the court to. But there may be cases in which this exercise produces a serendipitous benefit. And it's only in those cases, of which Whitehead is one, that the court in Whitehead is purporting or is departing from the general rule. So what Whitehead is not is authority for a proposition that in general the courts should depart from the established rule. It is at its high point is that there may be some cases, exceptional cases, where a departure is properly justified. And in our submission, that's the essence of the question for this court, is that does this case and cases that are like it fall into a category of exceptions to the general rule? In other words, does justice properly demand that the standard basis of restitutio in integrum should be departed from? Now, in our written case, we had, I think, suggested that Whitehead was effectively an application of Bulford to professional negligence claims. That is an oversimplification for which I apologise. It's not a direct application, and indeed the court does not suggest it is a direct application. What the court is doing in Whitehead is effectively drawing some support from Bulfer, but it doesn't go as far as to say it's a direct application. And my lords will see that at page 841, paper 843, electronic, in the judgment of Lord Justice Laws. Well, he says this, beginning at paragraph 25, second line. The defendant's solicitors are not to be held liable for failing to secure to the claimant an uncovenanted benefit, one which, upon an appreciation of all the facts, exceeds what the law would allot to him. In deciding what the damages should be in a professional negligence claim such as this, it's important, as I have said, not to take too narrow a view of the guidance afforded by the principle of restitutio in integrum, so as to leave out of account events relevant to the ascertainment of just compensation. Pausing there for a moment, the word events is important because it is, as in Bulfer, later events which Bulfer is concerned with, not later evidence of past events. On the ground only that they have happened since the notional original trial, and so were by definition unknowable at that time. And this is the reasoning. Lord Justice Law says this is supported by general considerations of justice, as with respect Lord Justice Smith plainly thought in the Judirect case, but also I think by two other factors. The first is the principle, so on and so forth, and he refers there to Bulfer. So Lord Justice Laws is using Bulfer as a matter that provides support. He's not going so far as to say it's a direct application of it. And similarly, in the judgment of Lord Justice Rimmer, page 856 on paper 858 electronic, paragraph 79. Where Lord Justice Rimmer sets up a hypothetical and says this. The second reason is most easily illustrated by the following example. Assume that HPN had brought, so the solicitors had brought the mother's claim on for trial in January 1995, and that she had recovered a judgment for damages in respect of past costs, but that because of the solicitor's negligent preparation of the case, she failed to prove what her future costs were likely to be, and so achieved no recovery under this head. So this is a hypothetical. But for such negligence, assume that she had a proper prospects of recovery in respect of future costs incurred over the following 20 years, so on and so forth. So he sets out the assumption. Paragraph 80, in my judgment, a claim that solicitors should compensate the estate on such a basis would fail. The court would apply the so-called Bulfer principle. So he introduces Bulfer by way of a hypothetical example that the matter would have gone to trial at a time when the mother was alive, but that she would die subsequently. So again, he is not suggesting that Bulfer can be applied directly to Whitehead. He has to introduce it as support through the hypothetical. And then the third judge in the Court of Appeal, Lord Justice Ricks, paragraph 54, 849 in paper, 851 in electronic, says this: I'm indebted to Lord Justice Laws for his judgment.
Can't be.
Paragraph 54, I apologise. I'm indebted to Lord Justice Laws for his judgment, which I've had the considerable advantage of reading in draft. I agree with his conclusion and his reasoning on the solicitor's appeal, which I too would allow.
I also agree with Lord Justice Rimmer's judgment in respect to the appeal, which I consider to be essentially consistent with that of Lord Justice Law's. So adopting perhaps both ways in which Bulfer provides support in Whitehead. So, on the facts, of course, whether Whitehead is properly decided does not fall to be determined on this appeal, because Whitehead was a case where a key event had happened subsequently, in that case the death of the mother, and in the case presently before the court there is no such event which has happened subsequently. But even assuming that Whitehead is properly decided, it's to be distinguished on its facts. But the underlying principle, plainly we would not disagree with, there will be cases where the courts will depart from the general rule where justice demands it. But we would invite your lordships to take the view that that should be done on a incremental, case-by-case basis, and that if there are to be new categories of exception from the general rule, they should be developed on the facts of cases where it is relevant. This is not that case. In our submission, there is nothing particularly unusual or exceptional about the facts of this case. This case does not fall within any of the established qualifications or exceptions, and there are no good reasons for the court introducing a new category of exception to cover this case. That being so, in our submission, this appeal must fail because applying the standard established test, the court asks itself what would have happened in the absence of negligence. The answer is simple. Mr. Watkins would have gone on to continue his claim for services which had a real prospect of success. That prospect is to be judged, as this court said in Perry, as a loss of a chance. And the matter will then simply have to be remitted back to the court, to the county court, for that loss of a chance to be assessed.
And how would it be assessed?
The county court judge would ask him or herself what would be the maximum value of the services claim, what are the prospects of that claim succeeding, firstly under the scheme, and secondly, if it didn't succeed under the scheme, under a claim before the courts, first of all, either settled or tried out. But the reality is, in cases such as this, the overwhelming likelihood is that the case would either succeed under the scheme or would not proceed at all.
And in doing so, presumably he would be entitled to have regard to what Mr. Tennant said as to not what had happened originally, but his contemporaneous assessment of the matters that bear on a service claim.
Absolutely. So the MAP 2 issues, the comorbidities, those would all be factors that the county court will take account of when determining
assessing a loss
when assessing loss of chance. They would absolutely.
And I think there were witness statements from family members in support of the loss of services claim. Is that
There were,
right?
and I think indeed, I think they gave evidence at trial, if I remember rightly.
all of which will be evidence that the court would have to consider when valuing that loss of chance. Now, I'm conscious that I haven't used up all my time, but I feel
We never mind if people don't use up all their time. We do mind if people waffle on to no good effect.
I hope I haven't done that. I wonder if there are any questions that I've not yet answered that I can assist my lady or my lords with.
It would appear not.
I'm very much obliged.
Thank you very much, Mr. Catmull. Mr. Telford? Miss Telford, sorry.
No, thank you, my lady. My loves.
Lady, a few very short points. I say this with a degree of reluctance, but what my little friend is in fact inviting you to do is to rewrite the law of tort. In establishing a tort, one has to prove loss. And that is the starting point in any case. And it was that failure which the learned recorder determined against the claimant. The learned friend says the case was never...
In establishing the tort of negligence, you have to prove loss.
My lady, you're quite right.
There are some torts which
There
are
are some
actionable
torts.
per se.
And I deserved that, and I accept it on the chin. The case on no loss was fully in play before the learned recorder and was determined by him in favour of the defendant. If I can take you back to paper 154 of the core bundle, electronic 156. The letter from Mr. Jackson's submissions are recorded in the second complete paragraph, just below halfway line. The defendant accordingly says this: the value of the shows in action arising out of the VWF was always less than the settlement figure which they achieved for their client, and so the claimant's loss is nil. There is no loss. The court, it is said, doesn't have to and should not assess the chance of the loss. It is possible to measure the true loss retrospectively and with objective accuracy.
Am I right in thinking the judge is doing that on the basis of revaluing the basic award, which people had been treating as 9,478, but if you rewrite that and say it can't exceed 4,500, the judge seems to be saying, well, if you use that as the start point, your services award is not going to take you above 9,478. He's not saying that the services award taken by itself has no value.
I think he is, in fact, saying that. I think he's saying, my learned friend Mr. Jackson's submission is this is a claim of no loss. There was no disability, which meant that the claimant recovered less than he was entitled to. Full stop. My learned friend Mr. Copnall's submission was this should always be assessed on a loss of a chance basis. And the judge, after my learned friend Mr. Jackson's submissions, including Charles, Duderek and Whitehead, are set out on page 155 paper, 157 electronic, including burden of proof, entitled to look at subsequent evidence. The court will rely on the expert evidence called in the professional negligence action. It's the only evidence it has. Whereas the loss of a chance approach to quantum should be adopted in relation to issues which are too uncertain to be tried on the traditional basis, and the correct approach may be a hybrid one. We go over the page to 156, paper 158, electronic. On behalf of the claimant, Mr. Copnall invites me to employ the loss of a chance approach. And he then sets out that argument. And then on page 157, paper 159, electronic, the learned recorder reaches his conclusion. I would not characterise the two approaches to the assessment of loss respectively urged upon me as mutually exclusive. They're complementary and both potentially relevant, depending on the facts of the individual case. If, as here, expert or other evidence which postdates the settlement or other disposal of the original action establishes beyond any or any negligible doubt that the claim could and would have been resolved only in one specific way had that evidence been available to the parties of the tribunal at the time, then the court in the professional negligence action has the full facts adverted to by Lord Justice Laws and should find accordingly therefore avoiding an uncovenanted windfall, effectively saying there is no loss. And then goes on to that. Another way of putting it is, as I found on the full facts, his services claim has no chance of success. So my learned friend submitted to you, the learned recorder dealt with this on a loss of a chance basis. He analysed the submissions both on the basis of no loss and loss of a chance, and said whichever way you approach it, the answer is 0. And that is consistent in our submission with the approach taken by this court in Perry. My learned friend took you to paragraph 20 of Lord Briggs's judgment on page 753, paper 755, electronic. And he said I had oversimplified or in some way inadvertently misstated what Lord Briggs was saying. And he took you to paragraph 20. For the present purposes, the courts have developed a clear and common sense dividing line which those matters which the client must prove and those which may better be assessed on the basis of the evaluation of a loss of a chance. And I put in parentheses here, this is the restatement of Allied Maples. To the extent, if at all, that the question whether the client would have been better off depends on what the client would have done on the receipt of competent advice, that must be proved by the claimant upon the balance of probabilities. To the extent that the supposed beneficial outcome depends on what others would have done, that depends on a loss of a chance evaluation. That's stage 2 of Allied Maples. When you're looking at what other people would have done, you do it on a loss of a chance basis. What Mr. Watkins would have done is established on the balance of probability. What his condition was doesn't depend upon what other people would do. It's a matter of factual determination. It falls within the balance of probabilities. It is only where one is dealing with third-party behaviour that one deals with the loss of a chance, because that is a matter which is assessed on risk, where the court can determine something as a matter of fact, such as condition, that is determined as a fact in the usual way. My learned friend made submissions about the judgment of Judge Hawkesworth. Can I just, for your note, remind you of paragraph 11? The question is purely a case management issue and does not require a detailed investigation at this stage. And then there's a typo. It says and to the extent, and it should have read as to the extent to which the findings made by the examining doctor at whatever level of expertise can or cannot be taken into account in valuing the loss of a chance to bring a services claim. Judge Hawkesworth was leaving open, clearly, because at that stage, the claimant's counsel was saying he also wanted an examination. And the dispute Judge Hawkesworth was resolving was what level of expertise should that doctor have? So far as Mr. Tennant's evidence was concerned, it was clear he was making an express finding. This is Mr. Watkins' condition. And nobody has ever suggested, and indeed it's recited in the judgment in Perry, that once you achieve a disability from vibration white finger, that disability remains. It doesn't deteriorate. Once you take away the vibrating machines, your condition doesn't deteriorate and it doesn't improve. So Mr. Tennant's assessment is the assessment which, in his determination, reflected Mr. Watkins' condition at all times. Lady, unless there is any other specific matter, I think I have used my allotted time and I am conscious of that.
Well, in fact, you haven't entirely used your allotted time, but as I said before, we don't encourage people just to go on for the sake of using the time which has been allotted to you. So thank you very much indeed. We're grateful to everybody for their submissions in this far from straightforward case. We have appreciated in the course of our reading into today's case that this is indeed a Welsh case. Mr. Watkins was a Welsh miner who lived in Tredegar and, dare I say it, consulted Cardiff solicitors and went for his Map 1 examination in Cardiff. So this is a thoroughly Welsh case, and we are delighted to have been having one as our final case, bringing to a close our first week's sitting in Wales. We have had a wonderful time here. We are most grateful to everybody for the warmth of the welcome that we have received by the Assembly, its presiding officer and its staff for making these premises available to us. Apart from the pillar in the centre of the room, I could not think of a more suitable premises in which to sit. By the First Minister and Counsel General, with whom Lord Reid and I had a very interesting discussion yesterday, by the whole of the local legal profession, bar, solicitors, silex, and legal Wales generally, by the High Sheriffs for almost every county in Wales, and the wider community. We have been made, as I say, to feel most welcome, and we are very grateful to everybody for that. And we look forward to the next time we're able to visit the Principality, which I regret to say will be after I have retired, but we will then be in the capable hands of my colleague Lord Reid, who I'm sure will be seeing to it in due course. And I just wondered whether Lord Lloyd-Jones would like to say a word or two in Welsh to bring these proceedings to a close.
Rydym ni yn ddiolchgar iawn i chi gyd am eich gwahoddiad ac am eich caredigrwydd. Mae wedi bod yn wythnos hapus iawn ac rydym yn ddiolchgar iawn i chi.
Thank you.